happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about jury instructions. Cases that should have gone to the Supreme Court of Canada, but didn't. If a jury is given instructions by a judge after hearing all of the evidence in the trial and then goes out for deliberations, something that happens sometimes is that juries can ask the judge to replay a certain portion of the evidence. This happened to Mohand Mohammed. In his case, the jury asked to hear a specific portion of a videotaped statement that he gave, which was inconsistent with his evidence at trial about what had happened that night. It was obviously going to be a central feature in a determination of whether or not his testimony was believed and ultimately whether or not he was going to be convicted. The judge agreed that he shouldn't just play a portion of the video back to the jurors, but that the jurors should be made to rewatch the whole video, but disagreed that the cross-examination on the statements he made in the video and the cross-examination that addressed the prior inconsistent statements should also be played for the jury so that they could have the full thing in context again. And this raises a very important question. We don't always know why a jury is asking a particular question. Obviously, they're asking because some piece of evidence appears to be important to them. Isn't situating that evidence in the entire context of all of the evidence that came out at trial the whole point of having a trial? To put all of the evidence in its context and to allow the jury to grapple with it and make its determination of guilt or not guilt on the basis of all of that evidence? The law says that triers of fact are required to consider the totality of the evidence before arriving at a credibility determination. So why is it that in response to jury questions, the answer can only be a portion of the evidence or is only a portion of the context in which that evidence is put, whether or not the jury is going to accept or reject that? In this case, it can lead to unfair results because we can't know what's in the mind of jurors when they're asking that question, why they want to know this additional piece of information, and what other information they may not be clear about as it came out at trial. Mr. Mohammed may have been, on the basis of this, wrongfully convicted, and the Supreme Court of Canada didn't take the opportunity to hear this case and to decide whether or not it was appropriate not just to situate the evidence in the context of the video as a whole, but also in the context of the evidence as a whole at the trial. And unfortunately, that step being not taken in this case leaves it open for other cases where not all of the evidence is going to be put back to a jury in response to a question about an issue that came up at trial. And that could have dangerous results. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.